I acted out of anger. My temper is my biggest downfall. I'm not afraid to take accountability for it.
You said there's been 8 prior instances, give or take. We've passed the law of the Safety Act. So now whenever somebody gets arrested, they go in front of a judge, and a judge deems their bond and whether or not they should be released or not.
On March 18th, 2025, Will County Sheriff's Office deputies responded to a domestic disturbance at a residential address in the Joliet, Illinois area.
What's up, my man? Here, come back here for stand against the car. What's going on? Look, so you were at work, you came home. So when you came home, what happened? Like, was anything said?
We just want to see the injuries. Yeah. LCC North 50. Do we have CSIF?
You didn't put your hands on her or nothing like that?
North 40, did you need him there, or did you want him to give you a call?
Nah, get him out of here, right?
Yeah. Do you want?
Can he 23 out here?
Nah, to be honest.
You know what? He doesn't want any injuries photographed.
You don't want nothing photographed or nothing?
Here's the thing. So.
Oh, you know what? I'll tell him.
Here's the thing. So I was gonna go talk to her.
She wouldn't have any injuries herself, would she?
If you want to hang out with me, I'll get started on this paperwork. I'm this back car. You might come in the back car. So what exactly happened?
Basically summarizing what happened? Or?
Yeah. Do you mind if we use the back of your car? All right. So here's this pen, and then if you have any questions, so like I said, just very basic stuff. Today's date, the time that this occurred at, and then the address.
All right.
What this footage documents is not just an arrest, it is a live demonstration of 3 intersecting legal frameworks that reshape how Illinois handles domestic violence calls. The first framework is mandatory arrest. Under 725 Illinois compiled statutes, 5/107-4, when probable cause exists for domestic battery, the arrest is not discretionary. The officer cannot choose to mediate, issue a warning, or walk away. The statute removes that option entirely. The arrest is a legal obligation. The second framework is primary aggressor determination, 750 Illinois compiled. Statutes 60/304 directs officers to identify which party caused more harm, not simply who called first. Relevant statutory factors include the extent of physical injuries on each party, the likelihood of future injury, whether either party acted in lawful self-defense, and any documented history of prior domestic violence. Here, the officer identifies visible scratch marks on the male victim's chest. The female subject's injuries are less pronounced by the officer's own observation. Under the totality of circumstances, standard, that disparity drives the arrest decision. The third framework, and the most consequential for this case, is Illinois' Safety Act, Public Act 101-652, effective September 18, 2023. The Safety Act abolished cash bail in Illinois. Every arrested person now appears before a judge at a detention hearing, typically the morning after arrest. The judge applies a 2-part test. First, whether the defendant poses a danger to any person or the community. Second, whether any conditions of release can adequately mitigate that danger. The state bears the burden of proof by clear and convincing evidence. The victim impact statement form the officer completes with the male victim is not administrative, routine. It is the evidentiary foundation of the state's argument at that detention hearing. The form captures prior incident count, approximately 8 prior episodes disclosed on camera, whether children were present, prior protective order history, and whether the accused has previously threatened witnesses. Every answer feeds directly into the judicial risk calculus. The officer's explanation of this process to both parties is legally accurate on every point. That level of statutory fluency, less than 2 years after the Safety Act took effect, is worth noting.
So today is the 18th, so 3/18/25. And then it is 10:19 right now. So just best estimate of when you think this occurred.
Oh, sorry. I didn't see
All
this.
good. You can't, no mistakes on here. You fill out any way you want. And then this would be the address. This happened at the house, right?
Yeah.
Okay. and then you were physically abused by, and they're wanting you to name the person, so whatever her name is.
Go into detail or just like
No, that's perfectly fine. And then this is going to be just a general summary of what led up to the physical abuse happening.
I don't know, just say at least 8.
Okay, and you have never contacted the police, and there's nothing wrong with that. If you just want to mark that you haven't cooperated in the past, and again, that's not a knock to you or anything like that. They don't really care. Just on the reason here, it's going to ask, I believe, for because if you want to put like childcare or something like that, kind of like how you were explaining to me why you haven't called on the line here, because if you want to put like childcare or something like that, because you rely on her for childcare, right?
Yeah.
All right. If you want to repeat her name, so you have identified blank, and it would be her name again. And then I can fill out this part. That's going to be my name and number. And then if you can just sign on that sheet, on that line, and then print your name on the bottom. This sheet is designed by the State's Attorney's Office too, so this one's kind of a weird one. There's going to be a bunch of random questions that you may or may not know the answer to. You just let me know, okay? I'm just going to run through them. Some of them might sound a little weird, just a heads up, okay? Has there ever been an order of protection issued between either of you? You guys reside together, correct? Same house? Yeah. You said there's been 8 prior instances, give or take. When would you say the first incident took place? Just so I have like a general idea. All right. Has she ever? I'm just gonna read off to you. She obviously did these today, so they're gonna sound dumb when I have. And again, there's no consequences to this. This is essentially referred to the State's Attorney's Office because within like the last year, we've passed the law of the Safety Act. So now whenever somebody gets arrested, they go in front of a judge, and a judge deems their bond and whether or not they should be released or not. So they take into account all these factors into making their decision. And so they want to know if she's ever injured the child. Would you say yes or no? No? Okay. Has she ever threatened any witnesses to any of these cases? She ever tried to take your cell phone away from you while calling assistance? She ever force entry into the...
It's a ways back. We could go up there. We could drive up there.
What's up? Let's take a couple out. 42.
21242?
21-4. Olivas. Okay, don't get scared. Everything's fine. Okay.
Come on, baby.
Hey, were you Delilah?
Yes, I am.
All right, so I need to speak to you.
I understand.
Okay, so what's going on? Delilah, I'm not here to say your version of events is wrong or his.
It's fine.
Where did this all supposed to room?
Yeah, go ahead.
North Unit, just shut us.
You want to show me?
Hold on. Let me go first. Delilah.
Okay,
And
you're
you
fine.
just go behind. You go behind me. Is there anybody else in the residence besides?
I'll tell you something, Delilah, when we're done, okay? Sorry, here, come back in here with me. So, here's what I have to say. We're going to let you get shoes. I'm going to take you for the domestic battery, okay?
Right.
So you'll be booked into the Will County ATF. And you're being very upfront with me, and that's why I'm being very cool with you. Did you want any of your... How long have you and Jenny been together? Shoes on and everything, and we'll get everything addressed, and I'll explain whatever you need to explain in the car. You'll obviously go to the jail, you'll be processed, and tomorrow you'll get set in front of a judge, and you'll be given a court date and a whole list of things, you know, as far as staying away from the residence. So when they do that, what they're going to do is say you can't have contact with this residence for 72 hours.
Okay.
So that's both of you are the parent of your kid.
Yes.
So
I trust her with my son. That's fine.
yeah, so that is That is not my concern. So what I'm going to get at is, this is the way it'll work tonight, but it doesn't mean anything will come from it.
Right. No, I know we gotta move with the custody and family court and all that.
Yeah, so once you'll get your day in court for domestic court, and depending on how
it's
you want to approach that, if you guys been together for 6 years, how old's your little one?
2.
You guys are still in that phase where there's a lot of stress.
Oh
if
yeah.
If you guys want to fix this relationship, you'll make the steps. And I'm not saying what to do when it comes to court, but if you guys choose to work this out, you make your own mind up about what to do at court.
Right.
Okay, so let's go downstairs, get some shoes on.
Thank you.
I gotta come back clear relative Joseph. That address, 1021.
And again, just so you know, Delilah, like my partner was saying, everything's gonna be documented. Your
I understand. Thank you.
Your statement of what you said that he did, and Lamar said you have to discuss it as well, okay?
Okay, that's fine. Let me just put my boots on.
Yeah, no problem. Do you want a jacket?
No, it's fine. I'll go like this. Put my boots.
Okay, we'll do this outside. I don't want to do
sorry.
this in case if anyone comes out. I want to see them. Okay, you've been incredibly polite with us, and I'm not about to do
I have a lot of respect for you. I mean, I was gonna pick out, but I'm a resident now, so there goes that.
You made the better choice.
Yeah.
All right, Delilah. So let's hop down here. Okay, so put your hands behind your back for me. Okay.
Do I give you my phone first? Or no?
Your what?
My phone.
Yeah.
Here you go.
Yeah. Well, we're gonna take that.
Do you have anything else on you that you shouldn't have?
that's-
Any drugs?
Anything you want to leave at home?
This is just my jewelry and my charger.
Yeah, you can leave that in there. I'll throw it in there for you. I'll put it like on
Taking
the.
anything like
No,
that tonight?
no.
Okay. And you said you don't want photographs done. You don't want any medical attention.
I mean, yeah, you can photograph it. It's fine.
You do?
Photograph it.
What's up?
She wants photographs.
She wants what? Oh,
Photographs.
she does.
Sorry, I'm sorry for doing
No,
that.
you're good. You're good.
Here's the thing, though. CSI's not going to be out here anytime soon.
He can meet you at the jail.
I don't know if he will.
Because I don't know how else we're gonna. She wants photographs. He didn't.
I mean,
so,
can I wait till we get there or no? That's just no. It's right
well,
now.
I mean, they could meet us over there. I mean, if she wants to take, because she's stating that he did that to her. So
You got your handcuff key.
yeah.
I think I lost my.
You could turn it off. Just turn it off. Sorry.
No, you're good.
Or you could let my mom know I'm getting arrested. That's fine.
No, I don't
Okay,
wanna
sorry.
tell her that.
Sorry.
You could call her from the
Okay.
jail. So you want me to call or what?
You do want photographs, though.
Or
Yes.
you could
Or can you?
on.
He's like, hold on.
Find out who it
LCC
is.
North 50, one female 95.
Find out who CSI is and have them give us a call.
LCC North 50. Who's 624?
I took a picture somehow. I don't know how.
No, 5624 is going to be Miller.
Miller.
Okay.
10-4, thank you.
See if I got it.
Yeah. And do you think you have any other like injuries or
No,
anything like
it's
that?
just
Any other? Because I mean, I could clearly see the stretch marks there. But in you, the stress, you know, having a 2-year-old and everything else, and sometimes, and I'm not saying just cause, right? So like me as a dad, you know, I know that if my wife is at home with my kid, that's an ass whooper right there. You know what I mean? It's like it's an ass kicker right there.
Yeah.
That you're dealing with a lot,
He doesn't let me
especially with a
work. He
kid.
doesn't let me do
You
nothing,
work,
so yeah.
you work, and once I leave work, I can't be done, right? Because I gotta go
Right.
home and kind of help her out. Like, hey man, you need to like chill, you know, because I'm pretty sure you're stressed out and everything.
Yeah, I already know this routine, but people take what they take for granted, and I'm
So-
just dealing with the repercussions of mine. I acted out of anger. My temper is my biggest downfall. And I'm not afraid to take accountability for it.
And I was just asking, like, have you ever been arrested before?
No, it's my first time. I've always been real
Law-abiding?
determined. Yeah, and just always kept playing my cards right. And he got the best of me tonight. So these are the repercussions.
And what was the comment that he made?
That's fine.
Don't make me regret it, Delilah.
Oh
You've
my-
been
no,
as cool
I
as
am not
possible
that-
the whole time, okay?
Sorry, I'm just gonna check my chest. Sorry.
No, you're good,
I'm good.
you're good.
Okay.
I'm good. I don't got nothing.
like I said, when people are really cool with us, I want to give them the benefit of the doubt that, hey, maybe you have something on you. Maybe it's
No, I
something
understand.
stupid. I'd rather, you know.
I'll tell you.
Just back this way more.
Oh, sorry.
So I can get you seatbelted in. 'Cause I don't want anything.
Oh, this is very uncomfortable.
Watch it,
Sorry.
Delilah. Cause you left your. I just gotta get this.
Sorry.
Okay, I got it. You can sit back.
Okay.
Okay.
There you go, Martha.
All right.
I know it's not comfortable.
No, yeah,
All
I
right,
understand.
New seats are.
I'm gonna lock your door, Delilah. Okay.
Now to the most significant legal issue in this footage. Miranda. Under Miranda v. Arizona, 384 United States 436, 1966, law enforcement must advise a person of their constitutional rights before conducting a custodial interrogation. Under Berkemer v. McCarty, 468 United States 420, 1984, those protections attach at the moment of formal arrest, not at the moment questioning becomes confrontational. In the rear of the patrol vehicle, the female subject voluntarily states, without being asked, that she acted out of anger and that her temper is her biggest downfall. These are spontaneous statements made post-arrest. The critical question is whether Miranda advisements were provided before this exchange. The footage does not show a Miranda warning at any point prior to these statements. If none was given, the defense has a viable suppression argument. A statement against penal interest made without prior Miranda advisement is not automatically inadmissible, but it is vulnerable. Under the fruit of the poisonous tree doctrine, established in Wongsun v. United States, downstream evidence derived from an unlawful interrogation may also be excluded. The absence of a visible advisement in a 20-minute body cam recording is not conclusive. It may have occurred off camera, but any gap in the record is a gap the prosecution must explain in court. There is a secondary legal issue embedded in the documentation sequence. The male victim initially declined to have his injuries photographed. The female subject later requested that her own injuries be documented. Illinois administrative regulations authorize officers to document domestic battery injuries as part of an official investigation regardless of victim preference, precisely because domestic violence victims often recant or withdraw cooperation at later stages of prosecution. The officer's decision to narrate injury observations directly into the body cam record, quote, scratches on your chest, kind of center, coming from the left center down, creates a contemporaneous evidentiary record admissible under the business records exception to hearsay under Federal Rule of Evidence 8036. Illinois follows a parallel hearsay framework under Illinois Rule of Evidence 8036. This oral documentation is a sound evidentiary practice that partially compensates for the absence of CSI personnel on scene.
All right, bro. You need anything else? Okay.
All right, I'm going to give you a couple pieces of paper that are going to go with you too. So just to explain to you what's going on, she is going to be placed under arrest for domestic battery, okay? So she's going to go down to the jail right now and then probably see a judge in the morning. So she'll speak in front of the judge, and then the judge will more likely than not release her in the morning, probably with bond conditions. So the bond conditions are probably that she's going to be able to not have any contact with you or the house or anything like that while the case is going on. I'm going to, although those bond conditions are most likely going to be in place, I'm still going to give you some information in regards to order protections. Do you know about order protections at all? It's kind of like a restraining order. Sort of, something like that. It would be that she's not allowed to have any contact with you. So there's also a bunch of other conditions as well that you can get placed. And all those would be on that sheet when you go to apply for it. So if that's something you would be interested in, it's done at the Will County Courthouse, 100 West Jefferson Street in downtown Joliet. You will get notified once she is released, either by us stopping over at the house or trying to make contact with you on the phone. Okay? Do you have any questions? All right, again, you don't want medical attention or anything like that, and there's nothing else we could do for you?
No, I'm good. Appreciate it.
Yeah. All right. If you do have any questions, you just let us know, okay?
Turning to victim rights compliance, the Illinois Crime Victims' Rights Act, 725 Illinois, compiled Statutes 120, mandates specific notifications to domestic violence victims before officers clear the scene. The officer provides the male victim with information on the order of protection process, the courthouse address 100 West Jefferson Street, downtown Joliet, notification procedures upon the subject's release, and the availability of medical attention. Each element satisfies a statutory obligation. An order of protection under 750 Illinois compiled Statutes 60 is separate from criminal bond conditions. It is a civil remedy available the next business day at the courthouse that the victim initiates independently of the prosecution. Bond conditions restricting contact are imposed by the judge. An order of protection is imposed by a separate civil proceeding. Both can run simultaneously. The officer's explanation of this distinction is accurate and practically useful.
I believe they're still wrapping things up on that end, so if you could just hang tight here for a little bit, okay? If you want to sit in your car, I'm more than cool with that.
Just ready to get some fresh air right now.
Okay. I'm gonna run this in my car and then, yeah.
Just like the redirection of everything. But I did see online because I wanted to be closer to my son, obviously, and now I might have to put him in daycare. But I did see online for an ad you guys hiring. I just wasn't sure how to go about it because as I read the description, it said that you don't need no college credit, or do you need college credit for it?
No, you do not need. I don't believe so. Were you looking for the correction side or the patrol side?
It was for patrol.
For patrol, I don't believe we're hiring on patrol right now. I know we're hiring in our jail for correctional deputies.
Okay.
I could be wrong though. I think you might. See, we're always changing because we go through waves on when people want to be the police and don't want to be the police.
Right.
I don't know if you need college credit. Do you have any college credit at all?
No, I don't. Just a GED.
I would have to look at it. I'm not 100% sure.
No, that's fine. I just thought I'd ask.
But yeah, we always post stuff on our website and then on
22 for yours.
Yeah, give it a try.
All right, we're good. You're good to go home if you don't need them anymore.
Yeah, no, we're good.
Okay, we're good, man.
Appreciate it. Thank you, man.
Yeah, if you need anything, give us a call, okay?
All right,
Best of luck to you.
Photographs. So they're all documented on my body camera. Okay, so in my report, I'm going to notate what I saw. So I see the scratches on your chest, kind of center coming from the left, center down towards the center of your chest. So all that's going to be documented. So everything, you know what? Let's get the show on the road instead of sitting here, and then I'll explain more to you. Okay?
Okay, that's fine.
County in North 40. I'll be en route to the ADF with that female 95. My starting mileage is 1034.6. 1034.6.
Now grades. The lead officer receives a B+. The mandatory arrest framework was applied correctly. The Safety Act explanation to both parties was legally accurate. Victim rights notification was complete. Injury documentation via Bodycam narration was a sound evidentiary initiative. The grade falls short of an A on 1 point. No Miranda advisement appears on camera before the female subject's post-arrest incriminating statements. Whether it occurred off-camera is unknown, but the absence in the record is a prosecutorial liability the officer created. The female subject receives a B, full cooperation throughout the arrest, no resistance, no escalation. Voluntary acknowledgement of responsibility demonstrates genuine self-awareness. However, making spontaneous incriminating statements in a patrol vehicle post-arrest without invoking Fifth Amendment rights is a significant legal error. The Fifth Amendment protects against self-incrimination. Silence costs nothing. Admissions can cost everything. The male victim receives an A-, full cooperation with documentation. Disclosure of 8 prior incidents provides the state with the pattern evidence most critical to the Safety Act detention argument. The initial reluctance to allow injury photography later reversed creates a minor gap in the evidentiary chain but does not undermine the overall record. Will County Sheriff's Office receives a B, Post-Safety Act training is evident in the officer's statutory fluency. Bodycam documentation policy is well implemented. 2 deficiencies hold the grade. No CSI availability on a domestic battery call with documented injuries, and no visible Miranda compliance protocol before extended post-arrest engagement.
So, all right, so here's how it's going to go. So I'm going to write a report on all this. Basically, his version of what happened, and then yours. So you guys got into an argument while in the closet. You know, you were putting a document in the backpack. He came over, grabbed your hair, and it was on. You guys tussled around in the closet. You know, you swung on him. He swung on you, as you're saying, right? Okay. So that's basically all it's going to be. So you'll go to the jail. You'll be processed, all that stuff. And then, like I said, tomorrow you'll meet with a judge. They'll give you a court date. And then they'll have information as far as what goes on with being released.
Okay, thank you.
Don't let this deter anything, okay? Don't let this be what, you know, ends a relationship. 6 years is a long time. I look like I'm 12. I can say I'm way, way older than that. I am in my 40s, believe it or not. Hold on a second. What's up, bro? I'm just right down the street. Just follow the street around. I'm Edgewater and Earhart. All right, bye. My partner has your phone, so we want you to have that. So, he's going to bring it. Don't let this be, if you guys want to work it out, then let that be the case. This is a minor speed bump, okay? Shit happens. I tell people all the time.
Oh, yeah, right. It's a part of life, definitely.
It's
just a learning from your mistakes and growing better.
If you were with somebody long enough, you're not going to have every day is going to be great. Not every day is going to be a walk in the park. You're going to hate that person some days. But like you said, it's a speed bump. So now what you do is you just learn from it. If he's worth it and it's worth saving, especially since you guys have a child in common, then by all means you go above and beyond and you give it all you can. And to me, he didn't want you arrested, okay? So we go by what we have presented as evidence. So we have 2 people that got into an altercation. One's a lot more marked up than the other. So, yeah, Marco has her phone. So, yeah. So this is not his doing. Okay.
No, I know. This is mine. This is mine. It's cause and effect. Trust me, it's cause and effect. And I understand it very well.
It's a combination of everything.
Yes.
It's a combination of everything. Yes. It's just the way it works sometimes. But you will overcome it, and everything will be better, and we'll go from there. Okay?
3 lessons from this incident applicable to any domestic violence response. First, Miranda is not a formality. In a post-arrest vehicle environment, officers who engage subjects in extended conversation, even empathetically, are operating in legally ambiguous territory. Advisement on camera before any substantive exchange eliminates the ambiguity entirely. Second, injury documentation cannot be contingent on victim preference. Illinois law provides the authority. The officer's body cam narration technique is a workable field solution when CSI is unavailable, but departments should have a defined protocol, not an improvised one. Third, the Safety Act changed the evidentiary stakes of first response documentation. Under cash bail, the arrest was largely self-contained. Under the Safety Act, the victim impact statement, the injury record, and the officer's report become the prosecution's entire argument at a detention hearing held within 12 hours of arrest. First response accuracy is now dispositive. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.